Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series, and this program is our Bill of Rights series. And this one, the Fourth Amendment. I'm a partner at the law firm of One LLP with offices in Southern California. I'm also an adjunct where I teach at the University of California, Irvine School of Law, where we do a Ninth Circuit appellate litigation clinic litigating cases, sometimes involving even the Fourth Amendment. Let's get going. We will start, as we do in all of our Bill of Rights series, where we should. Let's look at the actual text of the amendment at issue. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Magical language, really. As we do in all our programs, we start here because often what gets lost in the conventional discourse in the law, among lawyers, is even the language itself that we're dealing with. We talk about, warrantless searches are wrong. We talk about freedom of speech, and we have these obviously important shorthand catchphrases that may summarize what some of these amendments do. But it's always nice to look at the actual language, because that's what funnels and fuels the discussion that we are going to have today as we explore the Fourth Amendment, so that 1 hour from now, you will be the expert at the next cocktail party you're at. When people ask you about the Fourth Amendment and searches and seizures, you'll know what the answers to the questions are, or at least you'll know the issues. So let's take a look at sort of our agenda for today, the fun stuff we're going to walk through in this sort of wild and crazy walk through Fourth Amendment law. We're going to look, first of all, on the first kind of module that we're looking at here is on unreasonable searches and seizures. And here we will look at the home, the car, the phone, the person, the school, and sort of digital devices and data, which really starts getting at the modern world we live in terms of the digital footprints that we are leaving and that are out there at all times with us because of our cell phones or our GPS in our cars, you name it. And so this lets us look at some cool technology things that are out there. There's thermal tracking, GPS data, cell phone pings, and all of this stuff. And so we will look at these different venues, so to speak, for where unreasonable search and seizure issues arise. We'll also look, of course, at the warrant and probable cause requirement, the idea of things being in plain view, the search incident to arrest right, and then exigent circumstances, hot pursuit type situation, which can function as an exception to the need to get a warrant. And we will look at the remedies for violations, and that, of course, is the exclusionary rule. And we'll see how that intersects across different rulings in terms of what it means and how it works and where it doesn't always work the way you may think it does. The litmus test that we will talk about a lot as we traverse through this Fourth Amendment wilderness is the question of reasonable expectation of privacy. And one of the questions, the big questions that I think all of us ponder as lawyers, is whether the modern technologies that we are embracing with such rapid speed, and that our children, younger generations, are embracing with even greater acceptance, tolerance, in terms of giving up things that we may have felt were private. Whether that changing trend as driven by technology ultimately will ultimately alter our relationship with privacy as a people in terms of our rulings on the Fourth Amendment. After all, our kids today who hand over the entirety of their, what we would consider private data, to TikTok and Facebook and all these platforms and websites and have no concern whatsoever about sharing all of that, those very people will be the judges one day who get to decide whether something's unreasonable under the Fourth Amendment. Stay tuned. We will look at the Supreme Court's holdings in these major areas, and we are going to look at many important cases that have come down from the Supreme Court over the last century or so, from Weeks to Olmstead to Katz to Terry, Vernonia, Safford, Carpenter, and more. Many of those names may be familiar with you, some not so much, but soon they will be. And of course then, because we're looking at modern technologies of cell phones, there's long-term poll surveillance, data reconstruction. We'll even look at examples of abortion-related prosecutions based on, Google searches off of devices. And believe it or not, Jimmy Hoffa is making an appearance today. We're going to see how perhaps Jimmy Hoffa could be of great import to our modern technology world. What am I talking about? Stay tuned. Let's start again quickly. The Fourth Amendment's language, keep it fresh in your mind, pull it up on the screen, open your little pocket constitution, which I know you all have in your pockets. If you have to remember the language, here it is again. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Let's get going with a little bit of history on this, where this came from. The basic tenet of English political thought at the time of the colonies was the following. Every man's house is his castle. That very language has found its way into many of our judicial opinions, as you all no doubt know, and you may have seen. And where it comes from is a 1763 case coming out of England called Entick versus Carrington. And here's basically what happened. Officers entered the home. They were looking for politically subversive material. They had an ostensible warrant. Well, he wasn't happy. He sued, and the English courts held that the warrants amounted to a discretionary power given to messengers to search where their suspicions may chance to fall. If such a power is truly invested in a Secretary of State, and he can delegate this power, it certainly may affect the person and property of every man in this kingdom, and is totally subversive of the liberty of the subject. Now, this is a very, very important decision from England, which has been later identified by the Supreme Court as a very important case from England that underpins our Fourth Amendment that was adopted in the same generation as that case came down in 1763. And this helps frame what the founders were thinking. In fact, we can see that as far back as 1886 in Boyd versus United States from our Supreme Court that went so far as to say that case is the underpinning of our Fourth Amendment jurisprudence today. And that has carried on up until the 21st century. So, at the Republic's founding, as you see on the next slide here, to enforce the revenue laws, English authorities were issuing what were known as writs of assistance. And these were basically just general warrants. Here's a warrant, whoever has it, go search, look, whatever you want, take whatever you want, off you go, free reigning search. Now, these endeavors obviously were unpopular, as we saw in that case from England, and in the colonies, one example, for example, it was unpopular everywhere, but we have James Otis famously attacked these writs on libertarian grounds in the colony period in 1761, claiming that they were invalid because they conflicted with England's constitution. Now, he lost in that litigation that he tried to bring, and the writs were issued and used. But his arguments then became much cited in the colonies leading up to our revolution. You can look at Virginia and Massachusetts. Their Declaration of Rights expressly forbade general warrants, and they demanded that searches be reasonable. So as you see, we're funneling down to the language of the Fourth Amendment that was then introduced by Madison at the Constitutional Convention. On our next slide, we'll take a quick look at the proposed and final Fourth Amendment. Now, as it was originally proposed, the draft contained one clause which directly imposed limitations on the issuance of warrants, but imposed no express restrictions on warrantless seizures or searches. Here's the original language. The rights of the people to be secured in their persons, their houses, their papers, and their other property from all unreasonable searches and seizures shall not be violated by warrants issued without probable cause, supported by oath or affirmation, or not particularly describing the places to be searched, or the persons or things to be seized. Now, as it was ultimately adopted, of course, the amendment contained two separate clauses. The first protecting the right to be free from unreasonable searches and seizures, and the second requiring that warrants have to be particular and supported by probable cause. And that two-prong, two-structure type approach is where we are today. So let's get going on a little footnote question here of, we know we have the Fourth Amendment, does it apply to the states? This is the incorporation doctrine issue, and you've seen us talk about this in our whole Bill of Rights series here as we've walked through all the amendments to within the Bill of Rights to figure out if they've been incorporated and made applicable to the states. And so the fundamental idea here is that the protections of the Constitution's first 10 amendments, of course, only applied to the federal government. It's just expressly. They did not apply to state governments. And so the question then is, when the 14th Amendment was adopted after the Civil War, did its due process clause necessarily incorporate those first 10 amendments and then make them applicable to state governments? Because the 14th Amendment, of course, imposed limitations through its due process clause on the behavior of the states. And as we tried to figure out the scope of that behavior limitation that was placed on them, the question is, were we necessarily at the time incorporating the first 10 and now saying from this point forward, you're also state government subjected to the first 10 amendments? Now, we answer this question with a legal test, a methodology built around the idea, and this comes from the Griswold case, but it's from many, many cases, but this quote comes from Griswold, which is an exemplary case to use to just understand our incorporation test. And that the question is whether we have fundamental rights rooted in the tradition and conscience of our people and that are thus implicit in the concept of ordered liberty. If so, fundamental, implicit, and ordered liberty, then they're applied to the states via the 14th Amendment. When we're talking about the Fourth Amendment, the answer is yes, it has been incorporated. Mapp v. Ohio, Wolf v. Colorado, two cases from 1949, 1961 that have incorporated both the substantive standards of the Fourth Amendment and also the exclusionary rule that we'll talk about, have been made applicable to the states. So it's incorporated. State police, federal police, they're all bound by the Fourth Amendment. Now, what's the overarching rule that distills out of the Fourth Amendment that we're going to start peeling back through the case law? It's that unreasonable searches and seizures are verboten. A warrant based on probable cause is required for a search or seizure of someone or their things. The warrant can be excused based on certain factors depending upon the location and events. And constantly what we're doing here is balancing the individual's right to be free from governmental intrusions and the government's right and need to balance safety and the security of the public in certain circumstances. So let's frame the issue today. Before we go into the history, I want to start with that abortion-related prosecution situation I talked to you about in the beginning, because we're going to look at today, mid-21st century, first quarter of the 21st century, where we are, and we're going to look at how digital data is working and how this can be used to create and start prosecutions. And this is actually quite useful to assess first before we work back to the founding principles and see them evolve over time. And then at the end of the program, we're going to return to the technology applications that are affecting us today. So watch this short 3-minute clip here from YouTube.
So we're going to start with a discussion about Fourth Amendment challenges to device and account searches, because we think those are going to be the types of searches that you are most likely to see in abortion-related prosecutions. The reasons for this is that the contents of online accounts and devices they're incredibly effective evidence. Generally, in these types of cases charging people with crimes related to pregnancy or abortion, the prosecution relies on circumstantial medical evidence to show things like intent. But with device and account searches, they can actually demonstrate what a person was thinking through their browser histories, their search histories, or text chains with loved ones. That's why this data has been referred to as a window into the soul. We've also already seen this type of evidence leveraged in criminal cases charging women with crimes related to their pregnancies. And so I want to start by just highlighting a few of those cases we've already seen in the past. In 2013, Purvi Patel was prosecuted for feticide and neglect for allegedly ending her pregnancy through the use of abortion medication. And the prosecution's evidence included extensive amounts of text messages between Ms. Patel and a friend discussing obtaining and using abortion pills. There was also a search of her apartment that recovered an iPad with a customer service email from a website that sold abortion drugs without requiring a prescription. Another case from Mississippi in 2017 involved a woman, Letice Fisher. Her husband called 911 to report that she had given birth in the home. And when EMTs arrived, the 35-week-old stillborn child was not responsive. Ms. Fisher initially told paramedics she didn't know she was pregnant. And then in the hospital, allegedly, she admitted she knew she was pregnant, and made statements about finding it difficult to handle a pregnancy again. The medical examiner in that case initially determined that the cause of death was asphyxia. But for our purposes, and sort of by all accounts, some of the strongest evidence in that case turned out to be searches on her phone about how to buy abortion medication online. And that data was allegedly obtained through a consent search of the device.
So you saw there the role that our devices play and the near ubiquitous amount of data that we're creating and collecting. That can be used by the government to build cases. And so there we have texts, emails, Google searches, and the associated metadata that can leave a digital footprint that can then trigger search seizure issues for prosecutors, who then, in this context we took of abortion-related prosecutions, can be used to build a case against a person. This is an example of just how broad the data net is that we're casting today and what that means for us as individuals, for people. Now, let's go back in time before we come back to the present day. And we're going to go back to 1914, Weeks versus United States. This is at 232 U.S. 383. And here are the basic facts. The police went to the house of the defendant and were told by a neighbor where the key was kept. They found the key. They entered the house. They went through the defendant's room. They took possession of certain papers and articles. They turned them over to the U.S. Marshal. Later the same day, the police officers came back with a marshal who thought, maybe I'll find more evidence. And after being admitted by someone else in the house, it may have been a boarder given the facts, it appears, the marshal searched the defendant's room and carried away more letters and envelopes found in the drawer of a cabinet. Now, no search warrant had been issued. The defendant was indicted based on all these materials found and collected up, and he was convicted. Weeks went up to the Supreme Court. And here's what the Supreme Court said. The principles laid down in this opinion affect the very essence of constitutional liberty and security. They reach farther than the concrete form of the case before the court with its adventitious circumstances. They apply to all invasions on the part of the government and its employees of the sanctity of a man's home and the privacies of life. It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. It is the invasion of this sacred right. Now, this is a very important case because the fault line that you see is being laid down here by the Supreme Court is not so one much of physical locale, although of course physical locale matters, but it's focused through the idea of privacy rights and personal liberty and this personal privacy right that we all possess. So the case was reversed. The court held that you had to have a warrant if you want to enter that home and conduct that search and seizure. Let's fast forward and now look in the locale of the home. And this is Payton versus New York, 445 U.S. 573 in 1980. And these were a couple of consolidated cases that worked their way up to the Supreme Court. And here are the basic facts. Police officers established probable cause against the defendant in a murder case, and they went to the defendant's apartment to arrest him. They entered without a warrant. They did find incriminating evidence in plain view in the home, and it was admitted at defendant's trial. The police officers entered the defendant's house to arrest him without a search warrant and found narcotics in the dresser. That's kind of the related case. And here's what the court said. Physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. So the home is the heart. This goes back to the castle idea from that Old English case we saw. And this is what the court held. If there is sufficient evidence of a citizen's participation in a felony to persuade a judicial officer that his arrest is justified, then it's constitutionally reasonable to require him to open his doors to the officers of the law. Thus, for Fourth Amendment purposes, an arrest warrant founded on probable cause implicitly carries with it the limited authority to enter a dwelling where the suspect lives. But because no arrest warrant was obtained in either of the cases, the judgments had to be reversed and then sent back. So the rule again, searches and seizures inside a home without a warrant are presumptively unreasonable. If there's a basis to have probable cause to think a crime's been committed, go get your warrant and go do the search. And there would be some authority to then go in with some limited scope attendant to that when you're in the home doing the search. Now, there are exigent circumstances that can apply. And so here we're going to look at a case from the Ninth Circuit. And the question is whether, in the event of an emergency or exigent circumstances, as the doctrine is known, is that an exception to the normal warrant requirement that allows entry into a home and the removal of, in this case, a child from the home. And this is the case of Mabe versus County of San Bernardino from the Ninth Circuit. Basically, the facts are this. A woman calls the San Bernardino police and says that her younger sister, who was 14, was being molested by the stepfather. The 14-year-old said that, the stepfather had touched me through my clothing at night in my bedroom. And that was what was reported to the San Bernardino police. Now, about a month after this report was made, the social worker goes out and interviews the mother and the 14-year-old daughter at the home. And the mother said no abuse had occurred. It's not true. It was all made up. And the minor said that, while those touchings had occurred, nothing had occurred since that police report had been made a month ago, and so nothing had happened. And so the, social worker left. 4 days later, social worker gave a report to the internal agency at the county office, and the committee said, nope, this girl needs to be taken from the home and put into protective custody. And so the social worker went down and got the sheriff, they went out to the home, and they removed the daughter. There was no warrant, nothing was put before the judge. And so the question is, was this lawful under the Fourth Amendment? Here's the general rule. Imminent danger of future harm is required to show an exigency. Several facts viewed in the light most favorable to Mabe, the mother, undermine a reasonable belief of exigency. The social worker chose to leave the residence, let 4 days go past. The social worker had been told that there was nothing going on at that time. Social worker said she'd have to figure out if they needed to be removed. And this showed ultimately that the social worker's intent was to delay a removal, that there wasn't a perception of this need to do something because of imminent danger. And that's the important point that comes out of the case, and that is, if something's an exigency, then you rush in and do it right then and there. If you go out and investigate, then you go back and ponder it for 4 days, you have a little meeting of a committee to figure it out, that's probably a sign that you're not out operating under an exigency. You had time to go get a judge. Get a warrant from a judge and talk to the judge. And that's the basic point of the case. And so what the Ninth Circuit held is that the Fourth Amendment was indeed potentially violated here, as there weren't exigent circumstances to justify the warrantless removal of someone's child. And so the case was then sent back to the jury on this civil rights lawsuit that had been brought for the warrantless removal of the child. That's a good look at kind of exigent circumstances and how it works in terms of this genuine idea that it better be exigent if you're going to have a warrantless search or seizure. Now let's go to the famous case of Terry v. Ohio. This is now, we're talking about the locale of the person. And this is reported at 392 U.S. 1 from 1968. And here's the basic facts. An undercover officer on the street, he sees a couple people, never seen them before. He couldn't say exactly what drew his eye to them, but they just looked basically shifty, suspicious, whatnot. He'd been a policeman for decades, and so he knew this area. He'd been looking for shoplifters and pickpocketers for 30-odd years there, and he just had a routine in terms of his habits of observation, and certain things stood out, the way people were behaving. And so he looked over, and these people didn't look right at him. That piqued his interest, given his years of sort of dealing with people. So he followed them and approached them. And the men then mumbled something in response to his inquiries as he started talking to them. And so he grabbed one of them, spun him around so that he was facing the other ones, and patted down the outside of his clothing. And in the left breast pocket of the guy's overcoat, he felt a pistol. Arrested the guy got convicted. This guy is Terry, of course. And so this is a Terry v. Ohio case. And so the issue before the Supreme Court was whether it was always unreasonable for a police officer to seize someone and subject them to a limited search for weapons unless there's probable cause for arrest. Here's what they held. There must be a narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer, where he has a reason to believe that he's dealing with an armed and dangerous individual, regardless of whether he has probable cause to arrest the individual for a crime. He need not be absolutely certain that the individual is armed. The issue is whether a reasonably prudent man in the circumstances would be warranted in the belief that his safety or the safety of others is in danger. And if so, and that during that search for weapons, he had reasonable grounds to believe the guy was armed and dangerous, then it's necessary for the protection of himself and others to take swift measures. And so the point here is that a stop and frisk of those reasonably suspected to be involved in a crime is acceptable. And this is the person in public, of course. Now, the question in 1993, if we fast forward in time to Minnesota v. Dickerson, the question that Terry v. Ohio left on the table is, what if a stop and frisk feels a non-weapon possible contraband situation? And so here, police come to a known crack house. They see the defendant who begins walking toward the police, but when he sees the cops and makes eye contact, he abruptly halts and goes the opposite way. The police are now, piqued suspicion because someone's walking away from them. He enters an alley. He was kind of being evasive. He had just left the known cocaine crack house. So the officers decided to stop him to investigate further. They did their, stop and frisk. And this is what the police officer said. As I searched the front of his body, I felt a small lump in the front pocket. I examined it with my fingers and it slid and it felt to be a lump of crack cocaine and cellophane. Turns out it was. He was arrested. He was convicted. So the question was, does a stop and frisk for protective security of the officer extend to, reaching to find contraband? And so here's what the Supreme Court held. Although the officer was lawfully in a position to feel the lump in the pocket, because Terry entitled him to place his hands upon the jacket, the court below determined that the incriminating nature of the object was not immediately apparent to him. Rather, the officer determined that the item was contraband only after doing a further search, one not authorized by Terry, or an exception to the warrant requirement. Because this further search was invalid, the seizure of the cocaine that followed was likewise invalid. So patting down and just because you feel something doesn't give you the right to go figure out what that something is. If you feel something that's a weapon, fair enough, you have the right to go further to figure out if it's a weapon. And if you feel something that perhaps they indicated 100% you just knew by the feeling of it, oh, that's cocaine. How one would know that, I don't know, but if you knew it for sure, then perhaps arguably you could go. But the root of this one was that he just felt something, didn't know what that something was. And when you feel something, you don't get to go further to figure out what that something is, especially when it wasn't perceptibly a weapon. Now let's talk about the car, and we're going to talk about some basic rules of the car coming from a few cases in our Fourth Amendment jurisprudence, which is a good little overview. It's like the bar retests that we all took years ago for the bar, right? Number one, traffic stop is allowed where reasonable suspicion of a traffic violation or criminal behavior. And as you all remember, this reasonable suspicion is less than probable cause, but we're in cars on the public streets, and so if there's a reasonable suspicion that you violated a traffic law, aren't we all doing it every day probably because the traffic laws are so voluminous, or reasonable suspicion of criminal behavior, you can pull over a car and stop. That's Baremker versus McCarty from 1984. That's just an illustrative case. Number two, an officer may conduct a pat-down of the driver and passengers during a lawful traffic stop. The police need not believe that any occupant of the vehicle is involved in criminal activity. This is Arizona v. Johnson from 2009. Number three, the use of a narcotics detection dog to walk around the exterior of a car, subject to a valid traffic stop, doesn't require reasonable explainable suspicion. So if you got reasonable suspicion that there's a traffic violation, you pull the car over, a narcotics dog can walk around it, even if there isn't a reasonable suspicion that there happen to be drugs, which is why the dog drug may be smelling. Where there is probable cause, number four, to believe that a vehicle contains evidence of criminal activity, an officer may lawfully search the area of the vehicle in which the evidence may be found. That's Arizona v. Gant, 129, Supreme Court 1710, also from 2009. So these are the basic overrules of the car in terms of the Fourth Amendment. And you can see that the protections then that apply our privacy rights when we're in our car are substantially narrowed compared to the home when we're talking about the Fourth Amendment. Now let's talk about schools. This is another locale that comes up with Fourth Amendment cases. And this is a controversial case of Vernonia that many of you may remember from the mid-1990s. Vernonia School Board versus Acton from 1995. 515 U.S. 646 is the reported decision location. Here's the basic facts. Bunch of problems in the 1980s because of drugs in schools. You all remember the Reagan administration's war on drugs. And so in any event, by the 1990s, they'd adopted a student-athlete drug testing program, whereby at the beginning of the season, all the student-athletes were drug tested. And then, throughout the season, random athletes would be picked from a sort of a pool on a sort of just random search for which they would be subjected to a further random drug test. And this was just sort of done blindly, but this would happen, throughout the course of the school year. And so James Acton was then a 7th grader, and he was signed up to play football. And, he was denied participation when he and his parents said, no, we're not going to sign these consent forms that allow you just to randomly, do drug testing on our 7th grader. They filed suit to challenge this Fourth Amendment, this process under the Fourth Amendment as being unlawful. And here's what the Supreme Court held. A search unsupported by probable cause can be constitutional when special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impracticable. This applies to schools and no required reasonable suspicion even. The reasonableness inquiry cannot disregard the school's custodial and tutelary responsibility for the children. Legitimate privacy expectations are even less with regard to student athletes. Taking into account all the factors we have considered above, the decreased expectation of privacy, the relative unobtrusiveness of the search, and the severity of the need met by the search, we conclude Vernonia's policy is reasonable and was constitutional. Now, there were 3 dissenters crossing the political spectrum you see here, and they said, here's the basic quote, "I do not believe that suspicionless drug testing is justified on these facts." So there the idea is that it doesn't matter if it's a school, it doesn't matter if there's a decreased expectation of privacy. The dissent said suspicionless drug testing just violates the Fourth Amendment. But it was a dissent. So Vernonia stands as the current law today in terms of the highly diminished expectation of privacy in schools, in terms of the strictures of the Fourth Amendment and the need to have probable cause and a warrant and whatnot to engage in seizures and searches for drugs. Now let's talk a little bit about tech devices, and we're going to start with telephones and wires, and we're going to start with Olmstead versus U.S., and I put it here in red for you because Olmstead, of course, gets reversed. But in order to understand kind of where we are today in our Fourth Amendment, we should understand where we were in the beginning. And so this is a good case that was the first one to come up to the Supreme Court really dealing with technology and technology challenges, and it's at 277 U.S. 438. So we have telephones being tapped. There was no trespass on the actual physical property, but the lines were tapped. Evidence is gathered. They get then convicted of conspiracy for violating prohibition. And the majority said, due to the invention of the telephone and its ability to extend communication, people can talk over great distances with each other. And they said, the Fourth Amendment cannot be extended and expanded to include telephone wires reaching around the whole world. The intervening wires are not part of his house any more than the highways along which the wires are stretched are part of the home. And so the reasonable view of the Fourth Amendment is that one who installs in his house a telephone, which connects to wires outside the home, and then decides to pass messages over them, has no Fourth Amendment expectation of privacy in that. And that was the majority position in Olmstead. And so you can see there, the fault line that's running through that decision is more of a locale, physical location type limitation on the Fourth Amendment. The idea that Your home, yes, but if you send something out over a wire that goes across the desert, it's free to pick up by anyone. Now, a different fault line is looking at this through the prism of what is this all about? It's about our personal privacy concept and what we're doing, not the physical location necessarily. And this is a very, very famous dissent by Justice Brandeis, where he said, a principle to be viable must be capable of wider application than the mischief which give it birth. This is peculiarly true of constitutions. The protection guaranteed by amendments is much broader in scope. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. So this is a very important dissent, and it's a key concept that then animates modern privacy concepts, especially since Olmsted eventually gets reversed. But it shows the other analytical approach by which one can see the Fourth Amendment, which is a bulwark against government to protect our privacy rights, the right to be let alone. Let's look at Griswold v. Connecticut, just as a quick side note here, because Griswold, a more modern case, ends up talking heavily about the privacy concept that undergirds the Fourth Amendment. And it did this, of course, it wasn't a Fourth Amendment case. Griswold involved state laws banning contraceptions, but those laws were struck in part because of privacy concepts, and the Supreme Court then echoed in 1965 that many of the different Bill of Rights can stand and be seen as visions of privacy that are being protected against governmental behavior. And so here you see the bolded language where in 1965, Griswold said the Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And it's looking at this idea coming out of Brandeis's dissent ultimately about this being a privacy-driven amendment as opposed to a location-driven one. Now let's look how and when Olmsted was reversed. And this brings us, of course, to the case Katz versus U.S. in 1967. And here, the government had done, FBI agents had done wiretaps and whatnot. They'd listened to conversations that were being made from a public telephone booth where they had placed the wiretaps. They gathered all this stuff. They got the guy, got him convicted. Anyway, it goes up to the Supreme Court. And the Supreme Court said the government's activities in electronically listening to and recording petitioners' words violated the privacy upon which he justifiably relied while using the public telephone booth. And this was a search and seizure within the Fourth Amendment. Even though you're using electronic devices that don't penetrate physical booths and walls and whatnot, that was of no constitutional significance. That's very, very significant. And so what it coined then ultimately was this reasonable expectation of privacy test. And that's the key test that comes out of Katz. And this is a privacy rather than the Olmsted property type focus. So the conviction was reversed. Wiretaps of public phones require a warrant. And this is really a massive shift in Fourth Amendment policy and law enforcement ultimately as a result. So let's talk a little bit now about the digital age. And let's start talking about these sort of modern technologies that then push on these boundaries. Because again, with ever-growing advanced technology, we can have ever-growing digital sort of intrusions that don't come remotely close to physical locations too. And so here we're going to look at a case that went to the U.S. Supreme Court involving thermal imaging. And this is Kylo versus United States, reported at 533 U.S. 23. And this is from 2001. So we have the police using thermal imaging because they suspected that there was marijuana business going on inside the house. And they wanted to figure from this thermal imaging, is the house kicking off a lot of heat, which would be consistent with the types of lamps used to grow marijuana. And so the scan that took a few minutes was done in the middle of the night from the passenger seat of a car parked across the street, and then from the street in the back of the home. And the scan showed that the roof over the garage and a sidewall of the home were relatively hot compared to the rest of the home, and substantially warmer than neighboring homes. And so the agent concluded correctly, it turned out, that, they were using marijuana growing lights. They used that information to get a warrant. found the evidence, indicted. The defendant said, this evidence should be suppressed because you were scanning me and intruding me. And the motion to suppress was denied. Here's what the Supreme Court held. The use of thermal imaging device aimed at a private home from a public street to detect relative amounts of heat within the home was a search, as such a use involved obtaining, by sense-enhancing technology not in public use, information regarding the interior of the home that couldn't have otherwise been obtained without physical intrusion. So absent a warrant, the Fourth Amendment was violated, and so they reversed. So this is a very, very important case because it shows that as we have these modern technologies, if the police want to be in the public and use thermal imaging to see if my home is hot, they need a warrant. And by the way, the footnote that wasn't mentioned is, what about the fact that the police were also thermal imaging a whole bunch of other homes in the neighborhood to get their alleged relative baseline? All those homes were being invaded too. I don't know if the people sued, but that's a different story. Again, this is though an example of the privacy fault line that remains strong as at least through 2001 in terms of Fourth Amendment jurisprudence. Now let's talk about GPS tracking, Jones v. United States. This is from 2012. And basically we have Mr. Jones being arrested for drug possession after the police had been following him from a month. They'd put a GPS tracker on his car and he got convicted. And what the court held is that, what the government argued was that there was no search because there was no reasonable expectation of privacy in the undercarriage of the Jeep, where they put this little tracking device on, and where the Jeep was going over public roads, which are visible to all. And so that there is no reasonable expectation of privacy, the government said there, and so there was no Fourth Amendment type claim. That was sort of the position. But the Supreme Court said no, the Fourth Amendment was violated. There is a reasonable expectation of privacy, which we have said to be an expectation that has a source outside of the Fourth Amendment, either by reference to concepts of real or personal property law, or to understandings that are recognized and permitted by society. And so this idea, again, that you have an expectation of privacy, and you can't just say that because you don't, use the undercarriage of your car that someone can shove a tracking device on it and then track you on public roads. Not okay. Now, here's what the concurrence said, and this is an important concurrence because what the concurrence said is that with increasing regularity, the government will be capable of duplicating the monitoring undertaken in this case by enlisting factory or owner-installed vehicle tracking devices like LoJack right back then, or GPS-enabled smartphones. And then we have other modern modes of surveillance that don't depend upon physical invasions. And the concurrence here was concerned that the majority's opinion was sounding too much in trespassory or trespass testing like ideas that were too physical, locale kind of driven as opposed to true core privacy. Now, the majority came down in the right way, so it was just a concurrence, but this was the concern from this majority that are we shifting back to some sort of a property-centric approach where we're saying that one had a reasonable expectation of privacy because it's their car, and what does that mean if we're talking about electronic data being kicked off from other things? And so this is opening a potential fault line in the court, at least, in terms of modern technology and how technology is being used and working in Fourth Amendment jurisprudence, and whether we will start seeing breaks in the court along pure privacy right to be let alone, regardless of the technology concepts, as against perhaps more privacy concepts grounded in property-centric type concerns. So now let's look at an important case from 2018, and this is involving cell site data. And this is Carpenter versus United States. It's reported at 138 Supreme Court 2206, and again, this is from 2018. And so basically here we have the situation where the FBI identified cell phone numbers of several robbery suspects. And once they'd got those numbers, prosecutors were granted court orders to then go get cell phone records of the suspects. Now, this was not based on probable cause, but instead they went and got this, order to gather the data from the cell companies under a different federal statute that required reasonable grounds. Less than probable cause, obviously. So the wireless carriers had to comply, and they gave a whole bunch of cell site location information. The acronym is CSLI. And they gave it for the defendant, Timothy Carter's phone. And so the government then got 13,000 location points cataloging Carpenter's movements over 127 days. On average, 101 data points per day. So big picture, what this means is all day long, you're going around your business with your cell phone, and your cell phone is pinging the network at least 101 times a day, as we saw with Mr. Carpenter, maybe more today. And that pinging gives data to the cell phone company in terms of where you are. So you drove to the grocery store, went to yoga, picked up the kid, wherever you went. And that's all being tracked. And if looked at, one can piecemeal, put back together, a map of where you've been all day and your movements. So Carpenter said, this data's got to be suppressed. This can't be used against me. The Sixth Circuit said that Carpenter did not possess a reasonable expectation of privacy in this CSLI data that was collected because he voluntarily shared that information with his wireless carriers. In other words, the act of getting a cell phone requires this information to be given, and no doubt in those things we click, I agree to at some point when we bought our cell phone, in one of those 1 billion paragraphs, there's something about how they have the right to collect this location tracking data on us. And so that was what the Sixth Circuit held. So this then goes up to the Supreme Court. The Supreme Court said that the acquisition of this data was a search within the Fourth Amendment. Why? We have reasonable expectations of privacy in this data. And what they said actually is that historical cell site records may well present even greater privacy concerns than the GPS stuff we looked at in Jones. Why? Because they give the government almost perfect surveillance. They allow the government to travel back in time and retrace our whereabouts, subject only to what apparently are 5-year retention policies on this data of the wireless carriers. And so what the court said is, that's a grotesque intrusion. It's even worse than Jones. And so the Sixth Circuit had it wrong when they thought it went the other way. The government didn't get a warrant. They should have, based on probable cause. And so therefore the Fourth Amendment was violated. And so Carpenter stands today, still in 2023, as a seminal case in the digital age from the Supreme Court, a very, very important case in terms of our reasonable expectation of privacy in digital-based data. This brings us to Jimmy Hoffa. And we're going to take a quick look at an old Hoffa case and raise the question of whether the legacy of his case that went to the US Supreme Court, is it possible that perhaps it still has an impact for us in the modern technology age? And so here are the basic facts. Jimmy Hoffa had made incriminating statements to or in the presence of this informant, a guy named Parton. And this is a quote from the opinion of the Supreme Court. His invitee, he relied not on the security of the hotel room, but on his misplaced confidence that Parton would not reveal his wrongdoing. And so you can see already this factual establishment from the Supreme Court starts explaining the Supreme Court's perception that whatever he said or may have shared could have been a misplaced errant word to the wrong person, not an expectation of privacy type framework. Now, let's take a quick listen to the oral argument from the case for a few minutes because it helps really frame the issues and arguments about what was going on. So check this out.
As we understand the government's position, the government does not deny the illegality of Parton's repeated entries into Petitioner Hoffa's home suite throughout the duration of the test fleet trial.
Well, that may be agreed upon between you and the government, but I must say I have difficulty understanding why these entries were illegal.
Well, we say they were illegal because, as I will develop in further detail in this argument, Mr. Justice, we say that they were illegal because he was a government agent which was being hidden at the time of these entries into a home for the purpose of looking for evidence that they were therefore illegal, because as the government agrees with us, an entry into a home without a warrant by deception and an entry into a home without a warrant by force are equivalents under the Fourth Amendment in view of Goulet and the Gopart case.
Well, let's say when a plainclothes detective enters premises, to investigate whether or not illegal activities, criminal activities going on there. Is that an illegal entry?
Well, if he comes to the door as the helper of the household in the preparation of his defense and as his union colleague, but at the same time is hiding his identity as a government secret agent. Now, if your use of the phrase, Mr. Justice Stewart, of a private detective not connected with the government.
No, I said a plain clothes. That
but
is
connected with the government,
policeman
yes.
who wasn't obviously a policeman.
Yes. If he enters with deception that conceals his identity as a policeman, that is our position. Well, Your Honor, what they do, as we understand it, and I will advert further to this in the course of my argument, they at no point deny the illegality of the entry. They go further than that and state that in view of the illegal entry, had he been hiding in a closet, these admissions would have been inadmissible, but that the illegality of the entry is immaterial in view of the fact that the statements were directed to him, which I will come to in further detail.
All right, so here's what the Supreme Court held. What the Fourth Amendment protects is the security a man relies upon when he places himself or his property within a constitutionally protected area, be it his home or his office, his hotel room, or his automobile. It is obvious that the petitioner was not relying on the security of his hotel suite when he made the incriminating statements to Parton or in Parton's presence. The risk of being overheard by an eavesdropper or betrayed by an informer is probably inherent in the conditions of human society. It is the kind of risk we necessarily assume whenever we speak. So this is really an important, long-standing, decision that stands out there by the Supreme Court involving Jimmy Hoffa, because here's the question it raises. The decision had a very broad rationale for what it meant for Jimmy Hoffa to give up his privacy rights. They now divorced it from perhaps what were his expectations of privacy and said, well, you don't particularly have an expectation in privacy that you may not be overheard by an eavesdropper or betrayed by an informer. Well, what does that mean that you may not be overheard by an eavesdropper? We have the case law talking about wiretaps not being okay, which is exactly what eavesdropping is. And so as we consider this old Hoffa case, which still stands as good law today, as we consider how Hoffa will be layered into the Supreme Court's Fourth Amendment jurisprudence as we engage with more of these technology situations and the inherent sharing of data that comes from technology, the digital risk of being overheard, such as eavesdropped in one fashion or another, it's occurring all the time when we use our phone and GPS data that's being pinged on cell towers. And so this raises real questions about the inherent condition of using technology. Are we, in essence, giving up our privacy? And is technology, as it moves along, going to kill privacy more and more? And will we perhaps see the Hoffa rationale take on greater and greater significance, which is what that concurrence, as we saw, was starting to be concerned about if we start grounding expectations of privacy in the wrong playing field or the wrong potting garden. Now, what does the government do? Is there a workaround here for the government in terms of accessing stuff? And one of the issues is, that's come up is the government buying data. The bottom line is that private companies are acquiring massive personal data on us. Geolocation, IP address logins, you name it. All this stuff that we're doing all day long is being tracked, logged somewhere, and we've consented to all manner of things when we, click I agree to those impenetrable terms and conditions. Whether it's social media platforms, the use of cell phones, logging into your Microsoft email, via the internet, using a weather app, you name it. And many of these companies have the right to sell and use that data within certain legal frameworks, of course, that are out there in terms of how that data can be sold and used. And so the question is, can't the government just simply within the Constitution go out and buy the data like private actors and then use the data, go build a case? And is this ultimately an end run around the Fourth Amendment? And what we know from public data is that the IRS, Department of Homeland Security, Department of Defense, they've all spent millions of dollars buying data from data brokers. And so this has created some controversy in Congress. And so a bill was introduced in 2018 that said the Fourth Amendment is not for sale act. I mean, that's the title of it. Another great title. Great job to be the one who gets to come up with these names for bills. But the Fourth Amendment's not for sale act of 2018. And what it did was it sought to bar law enforcement and intelligence agencies from buying our geolocation data, the geolocation data of our citizens and the people of America, and or other sensitive information from companies that collect it, and whether it's a cell phone company, the app developer, or whatnot. The act didn't pass. So as it currently stands, there is a constant risk that's being run that, data could be bought by the government so long as it complies with legal frameworks. The data that's being collected can't just be sold willy-nilly because there are legal frameworks that apply. But that ability is out there and that data is being bought. And so it's going to take more litigation to really flesh out whether buying data like that can be used as an end run around the Fourth Amendment. Let's talk briefly here before we wrap up today about some other emerging issues given new technologies that are, hyper current and what we see coming. And so here's a situation where, we all have cell phones, we use our cell phones all the time, and some people don't have, passwords on their cell phones. And so what happens if you leave your cell phone lying around, someone picks it up, no password on it, they look at it, they see stuff in there that makes them nervous, they report it to the police, right? This has actually happened. And this involves a case involving Walmart. And so basically what happened is the phone was left at Walmart, employees found it, and they started looking through it. A little unclear why, probably to figure out whose it is. And they came across some images that were of concern to them. So they gave the phone to the police, and the police looked at the same files the employees had looked at, but the police also then looked at other files in the phone. And so the question is, can that evidence be used? And there's two components of evidence here we're talking about. The stuff that the employees looked at and told the police about, and then the additional stuff the police looked at that the employees had never told them about. Here's what the 11th Circuit held, and this has not worked its way up to the Supreme Court yet, but what the 11th Circuit held is that the officer did not exceed the scope of the private search when he looked at the photos, including full-size images of the photos that the employees had seen thumbnails of, or when he watched videos that the employees viewed. So when this phone is given to the police and they look at what the employees said we looked at and saw, if they overlap perfectly, that was okay, and that was not going to be verboten stuff. But when the officer then went out and did another further search within the phone and found more stuff, that exceeded the Fourth Amendment, because now the officer was looking at stuff that hadn't been relayed to the officer by the employee who had looked at it. This case is United States v. Johnson, case number 14-12143, coming out of the 11th Circuit in 2015. There's a similar case from the 9th Circuit in 2013, United States versus Tosley, 733 F. 3rd 816, which held that when an officer reconstructed a private search, clicking on a thumbnail and seeing a larger image, that didn't exceed the scope of the private search, where the police learned nothing new through their actions. And so this idea of reconstruction of private searches, where the private searches are lawful, not triggering the Fourth Amendment, but going further, triggering the Fourth Amendment, is an issue that's out there and will continue to be out there as we leave endless amounts of digital data open to people, and people may freely look at it and then go share it with the police. The other area of technology that we can look at is long-term pole camera surveillance. Basically what this means is, we've got these, utility poles for telephone or electricity or whatnot all around all our neighborhoods. And what happens when the police just leave long-term surveillance zoom lens cameras on there, and these stakeouts can last for months. They gather information. And currently, there's just simply a split, both within state courts and the federal courts of appeal, on whether the long-term use of these utility pole cameras really does require a warrant. Ultimately, these long pole utility cameras will go to the Supreme Court. You imagine, given the case law we've looked at, the requirement of needing a warrant will probably, survive. given the thermal sensor type ruling in the Carpenter case that we saw. But the jury's out if we're confronting, ever-changing technology, changing members on the Supreme Court, and perhaps changing rationales for where we root the Fourth Amendment. So here are our conclusions today. The core pillars to the Fourth Amendment. Our distilled rules are that we have a reasonable expectation of privacy in certain locations, and where we do, a search or seizure requires a warrant on probable cause. Now, where is the greatest area of expectation of privacy? The home. I mean, that's the core of the Fourth Amendment. Car, yes, but maybe less so to some extent. We have the stop law that we saw about. You can be searched and seized at schools where there's even less suspicion. We saw the breadth of Vernonia for drug testing, those types of searches and seizures. We saw all the rules on cars where there's the right to, if there's been a traffic violation, to engage in limited plain view type fair game and even searches and seizures. And we have a warrant requirement that can be suspended in the event of an emergency, a genuine exigent circumstance, such as evidence is going to be destroyed, there's imminent harm to someone, a suspect's escaping, hot pursuit, the like. But we also saw limits on that. The limits being, if you think there's an emergency, you better act like it. And if you don't act like there's an emergency and then you later do something without a warrant, it's going to look an awful lot like you were circumventing the warrant requirement when you had time to go get a warrant. The enduring legal debate that we confronted and we saw today in today's Bill of Rights program is the Fourth Amendment grounded in personal privacy rights, or is it more grounded in ideas of property trespass ideas? And what is going to be the garden that this lives in the coming generations? Really, really important fault line in the growing digital age with constant tracking from our devices and then satellites and then the cloud that are becoming more and more removed from us, and by our own behavior and conduct. We're freely giving up the data all the time, more and more. It becomes harder, one can imagine, to make the argument that one has an expectation of privacy in that which you're always giving up, like we saw one in the court saying. And so the query that I think we leave you with, leaves all of us with, is as our new generations have a completely different relationship with privacy, given their interactions with technology from very, very young age in terms of all they do, and as they age and become future jurists, future lawyers, will the zone that inhabits that, quote, reasonable expectation of privacy, will it necessarily change too? Maybe Jimmy Hoffa's case is going to haunt us from the grave. We'll see. Stay tuned. I hope you enjoyed today's Curious Lawyer programs. As always, we have lots of different programs in the Curious Lawyer series, ranging from dog law to CIA law to you name it. And of course, we've got the Bill of Rights series for you to enjoy. So stay tuned. Check out the other 10 amendments to the Constitution. And if you ever have questions, feel free to reach out. Thank you.